SJC-11429, Commonwealth v. Ryan Dalton.
Good morning, Your Honors. Pamela Alford for the Norfolk District Attorney for the Commonwealth Appellant. Chapter 6, Section 178E, subsection F, states that a judge may not make a determination that a sex offender qualifies for relief from registration when the sex offender was convicted of a sex offense involving a child. Because this defendant was convicted of a sex offense involving a child, the statute gave the sentencing judge no discretion to act in this case. Therefore, the Commonwealth respectfully requests that you reverses the judge's order relieving the defendant from the obligation to register as a sex offender.
Now, this revised statute was enacted soon after our decision in Doe. Right?
Which Doe, Your Honor?
Oh, the one that suggested that before you have can do this when you involve a requirement to register before there's an individualized hearing. There should be an individualized hearing when you're dealing with, when you're dealing with this claim, because it doesn't particularize. It says any sex act involving a child. It doesn't particularize the nature, the risk of violence, those kinds of things.
It doesn't, Your Honor, but there are two categories of cases. There are the cases that exist before the 1999 revised statute. I think maybe you're referring to the Doe number 3 or Doe number 4. And the critical distinction between categorization of sex offenses is pre-1999, to register meant that you had to give your information to a police station. And then there was a classification process where the Sex Offender Registry Board decided whatever steps were necessary. And the 1999 statute took the body of the Does 1 through 5, and also was under the
Response to Wetterling?
The response to Wetterling, as cited in my brief, there was coming up a 5-year deadline. My understanding it was, I believe, September 12th, and it was enacted September 10th, and it's in the section 1, which talks about all the different purposes. The very next sentence is, this is intended to comply with federal laws. 178D also specifically gives the Sex Offender Registry Board the ability to make regulations to comply with Wetterling. So there was a twofold purpose. One, the legislature wanted to fix the problems that have been identified, and two, they wanted to comply with Wetterling because there was federal money that went along with it. And so the 1999 statute changed, to answer your question, the idea that all you had to do before there was public notification in the 1999 statute was submit address information, bear information to the Sex Offender Registry Board, which was not going to be publicly disseminated. And in Doe, the 2001, I think actually it's Roe, in 2001, this court distinguished what had happened in the 1996 statute with what had happened in the 1999 statute, and found that was permissible. So to the extent that some of the pre-1999 Does suggested that there was a categorization issue, one, the 1999 statute changed that, and two, any categorization issue, because there is not public dissemination at this step, any issue would be before the board. It wouldn't be an issue here, where all 178E subsection F does is give a judge in certain circumstances the ability to preclude an offender from taking that first step. It does not, if the offender takes that first step, the board still has all the powers and all the duties and responsibilities in terms of appropriate notification and classification.
Apart from the dissemination question, going back to Wetterling and the Doe versus Attorney General, which came out, which is the 4:30 Mass one that was, I think it came out in August, just before this did, a month before. The Wetterling Act doesn't require this registration if the offense is basically a statutory rape. But do you argue that this language can be read in F, sub F, to not require sex offenses involving a child if they are statutory rape? Or do they still require sex? Because that's the definition in the Wetterling Act, that conduct which is criminal only because of the age of a victim shall not be considered a criminal offense if the perpetrator is 18 or under.
This perpetrator was 21.
I'm not asking you about this case. I'm asking you, how do we understand our legislation? And if we understand it, or do you understand it, do you see a possibility of interpreting this so that age-related statutory sex offenses are not included in the definition of sex offenses involving a child?
No, that's not the way the legislature wrote it, Your Honor.
Does involve statutory rape?
It clearly involves statutory rape. 178C defines what a sex offense involving a child is, and in that statute is rape and abuse of a child under GL 265, Section 23. The legislature wrote in a consistent manner, and I think that's a critical point, that this was not the only section where the legislature wanted to give some sex offenders the ability to be relieved from registration, but also wanted to comply with Wetterling. You see it in Section 178E, subsection E, which is motions to a sentencing judge by the Commonwealth. 178E, subsection F, which is where a sex offender is not sentenced to immediate incarceration, and 178K, subsection 2D, where the Sex Offender Registry Board has the ability to relieve certain sex offenders from the obligation to register. In all three sections, virtually identical language is used as to the categories of people who are excluded from relief. All three sections forbid relief for sex offenders who are convicted of a sex offense involving a child. And particularly in 178K subsection 2D, it notes it notes sex offenses involving a child where the sex offender has not registered for at least 10 years. That language mimics the Jacob Wetterling language, which says that offenses involving a minor must register for 10 years. And
the only language difference I could see is that in some cases, F, for example, conviction is used, whereas in the other reference statutes, adjudication or conviction. And I think in further language, sometimes adjudication as a delinquent is used. Do we read anything into that absence from subsection F?
well, in Ronald R.
In terms of non-delinquent adjudication, are we not including delinquent adjudication?
I think this court spoke in Commonwealth versus Ronald R. that because 178E subsection F uses the words conviction, it would not preclude a sentencing judge from making the determination for an adjudication of delinquency. But we're dealing with convictions in all three statutes. And I think that's very important because the crux of the defendant's argument was that there's a difference between the use of shall not in 178K and may not in 178E subsection F. There is no difference in this case besides the plain language of what may not means and what this court has used may not to mean, if you look at 178E subsection E, if you take the defendant's interpretation, it becomes entirely illogical because the defendant is reading may not as permitted not to. But 178E subsection E, which deals with motions before a sentencing judge seeking relief from for certain sex offenders, say a judge may make the determination. The judge may not make the determination if this sex offender has been convicted of the enumerated circumstances, including a sex offense involving a child. So if the defendant's interpretation is to be used consistently through the statute, then you have this untenable circumstance in 178E subsection E that it would be a judge is permitted to make the finding, but the judge is permitted not to make the finding. That makes no sense. This court, as the golden rule of statutory interpretation, so the statutes are to be read in their plain language or to be read to have an internal consistency. The internal consistency is that may not means the prohibition of permission, discretion, or authorization. This court has used these words consistently, including in Ventura, which was a sex offense registration case, which said that if one judge relieves a sex offender under 178EF as a matter of a probation violation, a second judge may not impose such sentence. I cite numerous examples where no doubt this court would be quite perplexed if a judge or a party undertook the action that this court said that they may not do. This court has also used the words interchangeably with shall not. In Curry is a very good example where this court said an attorney shall not circumvent a disciplinary rule through the actions of another. In other words, an attorney may not delegate to another which he himself is prohibited from doing. And I did take a survey of out-of-state cases, and those out-of-state cases show that may not has been defined as mandatory. It may not have been defined as the denial of permission, authorization, or discretion. In those cases where shall not is also used, the Getman case out of Washington is a good example. And in cases, particularly in the Service Member Civil Relief Act, that was a federal statute where the language was amended in 2003 from shall not to may not, and courts, many courts after that said the language is no less mandatory. The legislature spoke clearly and plainly and consistently when it enacted the 1999 law that it allowed certain sex offenders the ability to ask that they be relieved from that initial step of registration, but clearly said that sex offenders that had sex offenses that mimicked the Jacob Wetterling Act were not eligible for relief. And this court had said so in dicta many times. Because this defendant was convicted of a sex offense involving a child, the statute said that the judge may not make the determination before he could even get to wherever he could.
Remind me. So the information is filed with the Sex Offender Registration Board. When would they have authorization to release this individual from the registration requirements? After 10 years, or could they do it right away?
Under the statute, and this is not a retroactive application, this is a defendant who has been convicted after 1999, that he would, under 178K2D, he would be eligible for relief. My understanding in reading the regulations is no less than 10 years, but that would be, it's 803 CMR, I think 138 or 139 states it precisely.
Okay.
So if you lose, does the state lose federal funding under the Jacob Wetterling Act?
I think that's an interesting question, Your Honor, because there is, and I do cite this in a footnote, there has been subsequent amendments to the Jacob Wetterling Act, the Sex Offense Registration Notification Act of 2006. I am aware that, and that changed some of the durational requirements. It's not clear that we're in compliance with the 2006 Act, but where this is a case that is solely based on legislative intent. And the legislative intent on September 10th, 1999 was to comply with the Jacob Wetterling Act, and in doing so, they properly precluded this defendant who was, the category that included this defendant who was required to register under the Jacob Wetterling Act from having the ability to be relieved of registration under the Massachusetts Act. And if there are no further questions.
Thank you, Counsel.
Thank you.
Good morning. May it please the court, my name is Lawrence Murray, and I have the pleasure of representing Mr. Ryan Dalton before you today. Your Honor, it is a question of legislative interpretation, and it really comes down, I think, to a very simple proposition. And I think the focus is really, is there an ambiguity here in the legislator's use of this language such that the defendant, Mr. Dalton, should be entitled to the rule of lenity? And I think it's important to start with, as the court was focused on, what precipitated, what was the genesis of this whole change? And as this court is aware, it was in 1999, the decisions of this court that had led up to that 1999 amendment. And the thrust, if I can summarize those things, the thrust of those decisions were all these procedural infirmities that existed, and including, as Justice Duffley made reference to, the fact that you may have certain crimes which involve a child which don't fit necessarily the criteria of the protection that this statute is seeking to enforce, and that is the protection of vulnerable members of society. And in fact, I think...
You can't divorce the passage of this legislation on September 10th, 1999, a Friday, with the fact that we were going to lose a ton of federal money as of September 12th if we didn't pass something that complied with Jacob Wetterling.
Yes, Your Honor. But I believe it's always a balancing act. And I think while the legislature clearly intended not to lose that funding, it also wanted to make sure that it followed this court's concerns and orders about procedural, even though it didn't rise to the level of due process of fairness, Your Honor. And I think what's important here is that this judge, the hearing court, is being vested with discretion to determine whether or not a person who is convicted of one of these enumerated crimes should be relieved. Otherwise, it's mandatory. And we have two sections. We do have the 178 case 2D section, which I say is a corollary to this section. And both were enacted at the very same time in response to the same decisions and the same concerns. And one very clearly uses language, shall not do this thing. And shall not, Your Honors, I don't think there's any case, I may disagree with my sister about the interpretation of may not, but I don't think there are any cases that talk about shall not as being anything other than mandatory. So when the legislature enacted the statute dealing with the board's power, which, by the way, the board may relieve this person of registration requirement, but they shall not relieve these types of persons. Here we have sort of the inverse. We have similar language, but the court is required, if they make certain findings, the court is required to relieve that person. If, however, it involves one of the enumerated sentences or convictions, then the court may not do that. And I think that that language, when the top section is a mandatory requirement and the bottom is may not, I think we can't ignore that. We can't ignore that choice, which was made by the legislature at the very same time in response to the same concerns. And I think it makes sense. It makes sense to vest a hearing court with the ability to relieve this person of, but not require them to, because obviously these enumerated offenses present certain greater concerns for the likelihood of danger to the community or likelihood that the person may commit another offense. So I think it is important, as Your Honor said, to consider Wetterling, but it's also important to consider all these courts' decisions in interpreting the deficiencies that existed at that time. And this court has said that even though this is not a criminal statute, it's remedial in nature, that the rule of lenity applies. And I think at a minimum, Your Honors, at a minimum, the legislature's use of the word may not in this context creates an ambiguity such that should benefit the defendant when here the judge reasonably interpreted the statute and exercised its discretion to relieve Mr. Ryan after making the specific findings that were required. And this may be that type of case where the judge
So we certainly don't defer to the judge's rulings with respect to the legal import of the statute. I mean, there's no deference in that respect.
There's no deference to the legal interpretation, Your Honor, but I think that the judge was very careful in making the factual findings that it made, that this person did not represent any danger. This person did not represent a threat. And even though consent obviously is not a defense to statutory rape, the judge thought it was important to talk about the fact that as the hearing judge, as the one who sat there and heard the testimony, that this was a case that the court believed was consensual sex with a minor. So I think this is a good case to look at the statute and give it a careful look and decide that the use of may not, when the legislature clearly knew how to use shall not and used it in a corollary section of the same statute, is very important. And,
So the essence of your argument is that may not means may.
yes, Your Honor, it is. And I spent a lot of time looking through dictionary definitions, through case law, and I don't think that the case law is conclusive. It's certainly not in the Commonwealth, Your Honor. I wasn't able to find any conclusive case that said may not means that you shall not, that it's the same meaning as shall not. And particularly when the legislature used shall not in numerous occasions, why would it use may not in a corollary section and mean the exact same thing? I mean, to me, Your Honor, that doesn't make sense.
Well, I guess the problem is when I told my kids they may not do something, if they did it, and then they said, well, may not means that I have the discretion to do so, I don't think I would have been persuaded.
Your Honor, I appreciate that. But I think what makes this different in the context is we're talking about in the preceding section where the court is told specifically by the legislature, if you make these findings, you must relieve this person of this. But you may not if it fits within one of these other crimes. And what's interesting, Your Honor, I put to the Commonwealth in my brief, and I guess to the court, well, if the legislature didn't mean how this court, the lower court, interpreted it, then how would you write that? And my sister's suggestion is, well, we would have just gotten rid of the last sentence. But if you just get rid of the last sentence in that section, then it completely changes it. Then the judge is required, whatever the charge, whatever the crime, is required to relieve the person if the court finds that the person doesn't represent a danger and to the community and doesn't represent a risk of reoffense. So if you just eliminated that last sentence as is suggested by the Commonwealth, then it completely changes the meaning of that section. And I think it's a reasonable interpretation, Your Honor, to say that the use of may not, at the minimum, creates an ambiguity that Mr. Dalton is entitled to, the benefit of that, because this court has treated this remedial scheme in the same way as criminal statutes and applied the rule of lenity. So I would ask the court and urge the court to affirm the judge's exercise of its discretion under this. If there are no further questions.
Thank you, counsel.
Thank you very much.